Speaker, and I beg to move Amendments 18, 30, 31, 17 and 32 in my name. I'll start with Amendment 18. There have been many moral arguments put forward for the need of this bill, both in debates inside and outside this place. And the vast majority have focused on the prevention of suffering. There's also been desire for greater control at the end of life, but irreversible suffering has predominated. The principle of bodily autonomy, one which I strongly support in the context of full decision-making capacity and with certain important caveats, is used to justify the rights which this bill will grant. However, putting aside the debate surrounding the bill and focusing on the text and clauses itself, which is the task we face today at report stage, the provisions of this bill are silent of suffering, silent on control, and silent on all but a terminal illness with fewer than 6 months prognosis. If the principle is that we must prevent irreversible suffering, then all those suffering irreversibly should be able to seek physician-assisted suicide. If the principle is that we should give people control, another level of expression of bodily autonomy, then all adults who truly and freely consent with full decision-making capacity should be able to seek physician-assisted suicide. If these principles are circumscribed to an arbitrary definition of terminal illness, the inexorable conclusions must be that either their suffering or autonomy is more important than others, or their lives have less value. And we've seen that subtly imported into this debate. When requesting an assisted death is not framed as suicide because some perceive it as understandable. The underlying argument made, if you're terminally ill, of course you want to die. That's understandable. We must ensure that we don't, by accident or otherwise, enshrine value judgments on the worth of the lives of the terminally ill or the protections they should enjoy like everyone else onto our statute books. So I've tabled my Amendment 18 to expand the scope of the bill as much as I can to reduce the discrimination inherent within it. The maximum I can go to is to remove the 6-month restriction. I wish this amendment could go further. Madam Deputy Speaker, I know some members will wince at this provision, but if they do, I ask members to ask themselves, what do they think the principles and values within this bill are? How are they being applied? And are they being applied equally? It's why I believe, as drafted, this bill is incoherent and discriminatory. My amendment introduces some moral clarity into the bill, and if we don't, the courts will. Moving to Amendments 30 and 31. Madam Deputy Speaker, if we are to rely on the principle of autonomy to authorise physician-assisted suicide in terminal illness, then the express choice must be true and free. Autonomy needs help, though. A true and free choice needs to be informed. A true and free choice cannot be made under coercion. A true and free choice needs decision-making capacity. And I believe to rely on the principle of autonomy for the most grave of decisions, there needs to actually be a choice. Yeah. In the absence of relevant and available palliative care options, where's the choice? How can we rely on autonomy in the absence of choice? The prospect of people choosing physician-assisted suicide, not because it meets their needs, but because their needs are unmet due to a failure of provision of palliative care, would be a moral outrage. Absolutely. My amendments 30 and 31 would make sure that does not happen.
Will you give way?
I really can't, I'm sorry, given the time restrictions, but thank you. I now come on to my Amendment 18, pertaining to the test of decision-making capacity itself. So, Amendment 17. In English and Welsh law, we use the Mental Capacity Act to define capacity, and I believe it's right. The functional test of capacity is used in this bill too. We have common law tests of capacity in some circumstances, which arose before we have the Mental Capacity Act. However, in a decision such as this, a decision to end one's own life, this is not a decision that was permitted in the early case law leading up to the Mental Capacity Act 2005. There is no background of jurisprudence. There is no guidance. These capacity tests have not been done before. This test needs a bit more of a framework of support. So I've tabled Amendment 17, which lays out the minimum information that needs to be understood as part of the functional test of capacity. Critically, this includes information about the current treatment options, about doing nothing, and about proceeding under this Act. but also making clear physician-assisted suicide is not a medical treatment, it is a personal choice about life and death. Without my Amendment 17, this bill will fundamentally undermine the doctor-patient relationship. Doctors do not prescribe death. This bill must make that clear. And now finally moving to my Amendment 32. There has been some discussion about the inadequacies of the decision-making capacity test in itself as gatekeeper. In effect, that there may be circumstances in which, despite having it, the person is otherwise recognised as vulnerable. And of course, this is how our courts operate. The impact of depression or personality disorder on decision-making capacity can be subtle and elusive. And hey, I know I used to be a consultant liaison psychiatrist and did research in the area of decision-making capacity. This is tricky stuff to do, especially in the context of a request for an intervention rather than a refusal. So we should have trained psychiatrists at an early stage assessing capacity. They are expert at picking up these subtle cues, but all the other stuff that's going on. A request for physician-assisted suicide is not taken in isolation, and this needs to be understood and supported. And we need someone who knows how to use the Mental Health Act. Because of this mental order, you're doing this as a doctor, doing these assessments, you've got a patient in front of you. And if they've got a mental disorder and they're expressing a desire to end their life, you need to make sure that they get the right and appropriate treatment. And that may well be using the Mental Health Act. We need to make sure that this happens. I hope it would happen as part of the process as usual, but there is no safeguard within this bill to make sure it happens. Psychiatrists turning up at the panel at the end is not good enough. They need to be there from the start. Finally, there are broader issues about this in the interaction with protections to save life, Article 2 on doctors' duties. I will cover these in the second grouping and the incredible importance of its interaction with the suicide prevention strategy. Thank you.